Hello, everyone. My name is Ariella Wagner. I'm the founder of SunRay Construction Solutions. We help thousands of general contractors, subcontractors, and suppliers secure their lien and bond claim rights. Today, we have a very important webinar conducted by the extremely seasoned and talented Russell Ororick on getting paid using mechanic liens and bond claims. So without further ado, I would like to introduce the wonderful Russell Ororick.
Hi, Ariella. He's extremely seasoned. I like that. Is that a fast way to say he has gray hair? Perhaps. Well, good morning, everyone.
Or that you're just a really great attorney.
Oh, there we go.
Lots of experience.
I do other programs for SunRay, and this is one of the more important ones. I've been a construction lawyer now for 38 years, working in Ohio. I'm also licensed in Florida, but I really focus on representing subcontractors and suppliers, primarily in commercial and public construction. I also do residential stuff, and Ohio's got kind of a quirky law, but we'll go through some of it, so I think it'll become pretty clear. You know, I'm a lawyer, so with lawyers is always the fine print. I won't waste your time, but you can look at that. And let's start at the beginning. Back in 1991, Ohio changed its mechanics lien law from kind of an odd duck way of doing it to a combination of the laws in Michigan and Florida. And that says a couple of things. One, they had a pretty good law. Two, we didn't really like exactly the way it was, so we kind of worked on it and polished it our own way. And three, it gives you the hint that every state has different mechanics lien laws. Mechanics liens are creatures of statute, which means that virtually every state is going to have something different. So just because you know one state does not mean you know another. What happens after that makes it even more difficult, because what happens then is, you know, those lawyers, everything that that you see, well, the legislature didn't really mean it just like that, or here's how to read that. So now you have courts all over the state who are trying to determine what the legislature really meant in this particular circumstance. So that really means that you can't trust my knowledge of mechanics liens in Ohio versus in Texas or wherever else you might be working. You really need somebody who knows all of it. And particularly for notices of furnishing, someone like that is SunRay, because they work in all the states. They do a great job. So the notice of furnishing is your entry into the mechanics lien system. But it's not just an entry point to give you the opportunity to file a mechanics lien. The last thing you really want to do, okay, maybe not last, but kind of further down the line, you don't want to file a mechanics lien. If you can ever avoid it, if you can avoid it, you want to. And why would you want to? Because you got paid. The notice of furnishing gets you on the list to be paid. So clients ask me, well, when should I do a notice of furnishing? Should I do it on every job? Yeah, that depends. You know, if you're working for, you've been hired to do work for a company that has paid you every time within 10 days of your invoice, and this is a $5,000 invoice, why would you bother? If it's a guy who pays you every time within 10 days, and it's a $100,000 invoice, now you have a different question, because the guy who always pays you every time can probably float $5,000. But when it gets to 100, and let's say something goes wrong with the project, and your friend can't front you 100,000, and just to make sure that you're going to be paid, he'll take it out of his pocket. You want the opportunity to be able to tag the people up ahead of him, to be able to tag the well, in Ohio, we call it the original contractor and a private project, and a principal contractor and a public project. But, you know, the contractor that has the contract with the owner. So you want to be able to tag them. You want to be able to tag the owner of the project so you can get paid. Well, those people don't want liens on the project either. This notice of furnishing thing is probably the most important thing you can do to protect not the right to get paid, but to protect the likelihood that you are going to get paid on time and in full every time. This notice of furnishing gets you on the list. You know, you're supplying to a subcontractor, or you are a subcontractor and you're working for a contractor, and you as a supplier or the sub, the person 2 steps ahead of you doesn't necessarily know that you're working on the project. The owner probably doesn't know that you're working on the project, and the owner is the one who is going to pay the contractor, to pay the sub, to pay you. This notice of furnishing makes that owner, puts that contractor on notice to say, wait, before I pay the person below me, I want to assure that there are no liens on the project. Who has lien rights on the project? These folks who did the notice of furnishing. A, they're professional, but B, they have stepped up. They have gotten on my list, so I know to ask the person below me, the contractor or the subcontractor, whomever's ahead of you, for your lien waiver, to make sure that they are paying him, he is paying you, and you're happy, you're not going to file a lien. So get that notice of furnishing done every time. The other thing you need to do is, kind of in the middle of the project, watch out for your lien waivers. They make you sign these lien waivers, and the problem with them is they are frequently way overbroad. Have you gotten paid? Have you gotten paid in full on this draw? And when I say in full, I mean, did they take any retainage out? Did they hold back any money for anything? Yet they gave you a lien waiver, which almost always says that you are waiving all liens, claims, bond claims, choses in action, and a whole line of things from the date of this waiver. Okay, well, have you been paid in full, including your retainage? No. Okay, you're already over waiving. The second one is, through the date of this waiver, you're not getting paid through the date of this waiver. Let's say you supplied your material on day 1 of the month. You get to the end of the month and you've got your pay application in, or your invoices sent to the people ahead of you. They get it all in line. And so now send it up to the owner. A whole month has gone by. The owner isn't going to pay the contractor until the end of the next month. So now you're 2 months behind. And the owner is going to pay the contractor, and the contractor has 10 days under the prompt pay law to pay the subcontractor, who has 10 days to pay you. So now you're signing the lien waiver today, and you've already lost how much? 4 weeks, 8 weeks, 10 weeks, if everything just went on time. So pay attention to your lien waivers. They should be conditional lien waivers. You can tell the difference because at the beginning, they usually, unconditional ones start out and say, in consideration of the sum of $5,000, the receipt and sufficiency of which is hereby acknowledged, the undersigned does hereby waive this, that, and the other thing through the date hereof. Okay, that's not what you want to sign unless it's the final lien waiver on the final draw, including your retainage. What you want to sign is the conditional lien waiver, which says upon the receipt of a check in the amount of $5,000, and when that check clears the bank on which it's drawn, this shall serve as a lien waiver for this amount of money through this date. Cross my heart and hope to die. That's the right one. And when you get that check, give them an unconditional lien waiver through the same date. That's the way it ought to work. Conditional lien waiver before you get paid, appropriate lien waiver that's unconditional after the check clears. Do it that way, and you'll be in a better position to claim all of your money and not worry that somebody is going to jump up and say, I'm sorry, you waived your liens, and because you waived them, you have no more opportunity to file your mechanics lien. So you did all that stuff, and now you're not getting paid. Now you're mad. The line of things that you can do is, if you don't want to be extraordinarily aggressive, sometimes, you know, it's kind of like when we had détente with the USSR, not to drudge up old things, but, you know, we had a mutually assured destruction. So no one would push the button. Well, a mechanics lien is sometimes like the atomic bomb. On a project, it does a whole lot of things. We'll get there in just a second. The notice of intent to lien does a couple of things. It says to the people above, this guy's running out of time to file a lien. He's got a lawyer involved. They're ready to file a lien. Let's look at the lien waivers. He has lien rights. He didn't waive the liens, so we better pay attention. And now everybody starts pushing down on the people below them until they get to you. So the owner pushes on the contractor, who pushes on the sub, who is going to get you paid or do whatever. You still aren't paid. Now you file the lien. You told them you were going to file, and then you file the lien. Now, there are some contractors who I respect. And when I know they pay their people on time because they're that kind of contractor. I have good relationships with them. I call them ahead of time. I've got an order to file a lien on this project for ABC. If ABC is on here, I'm not using you as an example, just the letters in the alphabet. So they haven't been paid, their lien time's running. I'm going to file a lien next Tuesday. What can you do? And I've got one guy who, as soon as I call him on his cell, and he never answers hello, he always answers with a little chuckle in his voice, who haven't I paid now? And so we work through it, and he says, let me find out, I'll call you back in 10 minutes. He calls me back in 10 minutes and says, I'll have you paid on Monday. There's a dispute. We haven't been paid. Please file the mechanics lien. I've been warning the owner that if they don't pay me, a mechanics lien is going to be filed. Or there's a dispute. Do what you have to do. File the lien. We got it. Go ahead. And so it gets you in the better line now. The line where if everything falls apart, you can at least claim the money that's, shall we say, left. You know, if a project really falls apart, the first one that's going to get paid is the bank. And after all the bank gets paid, then the taxman will get paid. And then the mechanics lien. All mechanics liens filed on the same project have the same priority. And that means the order in which they're paid. Why that's important is just because you were an early finishing contractor and you do the site work doesn't mean you have a better right to be paid and that you should be paid in full before the painter or before the landscaper. So everybody who files a lien gets thrown into the same bucket, and if there's enough money to pay everybody 100 cents on a dollar, everybody gets 100 cents on a dollar. If there's enough to pay 50 cents on a dollar, everybody gets their pro rata share of that 50 cents. If you're on a public project and some private projects, there's also bond claims. There's bond claims by statute on state and local projects and by federal statutes on federal projects. By the way, there's no mechanics liens on federal projects. You just have to do bond claims. So the bond claim is kind of a belt and suspenders, where am I thinking? Belt and suspenders type of remedy. Now, a mechanic's lien tends to be a faster remedy. So you're making a claim and you have put a wrench in the machinery that gets everyone paid. So now they want to look at you right now. But if there's not enough money and there's a payment bond, you want to be sure that you file a payment bond claim too, because bond money is slower money, but it's more sure. Because the surety has this payment bond, which is for the contract value usually, which means there's still money around. It doesn't matter that the bank got paid, there's still money around to pay you. That's why you want to get a bond claim too. Sometimes you look at it and you say, should I do both of them? Should I do one of them? If you don't need your money right away and you don't want to spend the money on doing both of them, it depends on how much money it is. You know, if you're chasing $5,000, doing both may be overkill. So you pick the one, you know there's enough money left in it, you know they'll pay you, do the lien. If you're not sure there's enough money and you don't need it today, well, today is, you know, kind of a relative term. You don't need it in the near term. You're going to be out at least 90 days before you get paid on a bond claim. I mean, I've been doing this for a long time. The fastest I ever got paid on a bond claim was 4 weeks. And that's because the contractor had gone out of business, and it was clear that we had supplied our equipment to the project, and it was installed and working. Nobody had any issue. Nobody raised any fuss. They paid us. But that's the fastest ever, because the surety has to assure that the claim is a good claim. Because if they pay it without finding out it's a good claim and it turned out to be a bad claim, then the principal, you know, the contractor, doesn't have to refund the money, because on bonds, they get guarantees from the company that they're going to get paid back. So bonds are slow money, but sure. You think about it, I will recommend to my clients which they should do. And I'll say, if you don't want to spend that much money, and really it isn't a whole lot of money, you know, do this one or do that one. You'll get a proof of claim. Sometimes it comes to me when I filed your bond claim. Sometimes it goes directly to you. When that happens, if you haven't done one before, they're really pretty easy. Call me. I just walk you through it, and you'll see it's simple. If you're still not paid after all of that, now you enforce the claims by a civil action, which means a lawsuit. If you're chasing the bond, it's just a regular lawsuit. If you're chasing the mechanic's lien, now it's a foreclosure action. They could have bonded off, which is a different bond, the mechanic's lien. If they do that, it takes the lien off of the real estate and puts your claim on a different bond, which is also a good thing, because now you don't have to do the foreclosure. You just go directly to a lawsuit naming the parties who owe you, and maybe up the chain, depends on where you are in the whole thing, and the surety. So you want to get paid, this is what you have to do. Why do I need to see the notice of commencement? Because the notice of commencement has everything in it you need to A, file a lien, B, file a bond claim, and C, serve your notice of furnishing. Serve that notice of furnishing. You need to do it in Ohio, within 21 days of your first day of work or supply to the job. If you don't do it within the first 21 days, you'll lose 1 day of lien right for every day you're late. So if you serve it on day 1, you're good. If you serve it on day 21, you're still good. If you serve it on, and serve it means depositing in certified mail. If you serve it on the 22nd day, now you lost lien rights for the first day. If you're a subcontractor, does that matter? Probably not that much, because if anything gets paid, it's your first draw, and you only lost 1 day. Well, what if you're a supplier and you had 1 day to supply all of your equipment and you dropped it all off on day 1? Well, on day 1, You would have been good if you served it within 21 days. Now you're on 22, you just lost your lien rights. Can you get them back? Well, it's a little tricky, but if you send a request for notice of commencement, you serve it on the owner, and the owner doesn't get the notice of commencement back to you within 10 days of the day they received the request, then your time to serve your notice of furnishing stops and doesn't start again anew until they get it to you. So if you're on the 22nd day, you serve this request for notice of commencement, they get it to you on day 12, you have 21 new days to serve your notice of furnishing. So keep that in your quiver as something that you may be able to do. I wouldn't use it every time. You're going to get a lot of fight on it. I tell you, you're going to the Ohio Supreme Court on it if it's a big deal lien. So because everybody's going to fight it, but it's right in the statute. So, use it sparingly. Use it only when you've truly screwed up. And if you get all your requests in, well, I recommend that when you're ready to do a notice of furnishing, not when you're ready to do notice of furnishing, when you get a contract, send your request to do a notice of furnishing over to SunRay, and they'll get it going for you. And if you do it right away, there's plenty of time. There was the statute on when you have to serve your notice of furnishing says at any time after the notice of commencement is filed, but within 21 days after your first day of work on the job. And back in 2011, there was an awful case that said, well, you had to wait until you were on the job before you could serve it. And that's just not what the statute says at all. In 2019, we took a case to appeal in Summit County Court of Appeals, which is, I'm in Cuyahoga, that's one south of us. And that's the 9th district, which includes Medina. And we won that one that says, no, the statute says at any time after the notice of commencement is filed, but within 21 days after. So it means that that whole time period, if I know I've got a lot of elevator installers, elevator contractors, and they tend to send me their notices of request for notice of furnishing right away. And they're not going to install for 6 months. What do? Do I wait? I had to wait until the 6 months were up because of that old case. Now that we've got the new case, we can do them right away. Why do that? So you don't forget. If you're telling SunRay, well, if you're waiting to say, okay, I'm not on the job yet, I don't want to do it yet, and all of a sudden you forget, you're out of luck. You have a hard time fixing it. Get your contract, send it over to SunRay. If you want them to wait to file it, tell them to wait to file it. I wouldn't. I'd have them do it right away. So avoid death by waiver. We've talked about that before. Watch out for those lien and bond claim waivers. They're everywhere. They're included in, sometimes you get change orders. And in a change order, all you're looking at is the time for your change order and the money. And it says, oh, by the way, and you waive all your lien rights and bond rights. Be careful. Read this stuff. If you're concerned about it, just call me. Let me see the lien waiver. I'll tell you. It's no big deal. We already talked about this. Lien, bond claim, neither, both. That's, discuss that with your attorney and figure out exactly what you want to do there. So your lien's filed, your bond claim is served. What do? Well, at this point, you're going to negotiate for a resolution. Sometimes they're just going to say, okay, here's your money. And frequently, more often than not, that's what happens. I'm simplifying it a little bit. What I'm saying is there's not a whole lot of negotiation other than when you're going to get paid. But you'll frequently get paid. Now, if you are negotiating with somebody, just assume that everything you say is being recorded. So, consider recording it yourself. If you're sitting down face to face, turn the record button on your cell phone. Or if you're on a phone call and everybody's within Ohio, get the app that lets you record your telephone call. If they're across state lines, be careful, because now you're into federal law maybe, or you have to look at both states. That's how Linda Tripp got caught up. You remember back with the blue dress incident. There was a telephone call to Linda Tripp, who was the kind of whistleblower there, and she was across state line, but she turned everything in. She's the one who made the telephone call, and she's the one who recorded it. Maybe she didn't make the call, but she recorded it. And it was an illegal call because one of them was sitting in DC and one was in Virginia, and they had different rules. So if it goes across state lines, be real careful. What happens when you get that first call? And their attorney is probably the one who's going to call. He's going to say, that contractor owes you nothing. The claim is a slander of title. I don't know how frequently I hear that. Take it off right now and we'll pay. I also, if they call you, what they'll say is, take this lien off right now, or you'll never get another job from me again. And I agree, that's probably true. You're never going to get another job from them unless you're low. And then, well, you'll get the work. It's probably not a slander of title. Every once in a while, something's wrong. But before you take it off, if you get that call from their attorney, call your attorney. Have him or her deal with their attorney, because I can tell BS better than a lot of people, better than people who aren't lawyers or people who aren't construction lawyers. If you're going to hire a lawyer, don't call your cousin Eddie to do your construction work if cousin Eddie, the lawyer, is a personal injury lawyer, or your cousin Vinny, who's kind of a criminal lawyer. Don't call me to do your criminal work. Hopefully you don't have any. But I don't know criminal law. I've got people in my law firm that do, and I can shift you over to them. But we don't want to do that. Call the right lawyer. So if you've got a great construction lawyer, call them. Have them do it for you. The price you're going to pay them to do the work is nothing compared to what you can give up, because you got buffaloed by the lawyer. They're also going to ask you to prove that you did all of your paperwork right. The number one thing that I get is a request for a copy of the green card that we served our notice of furnishing. And that's going to be vital. That's why you need to serve it by certified mail, and you need to get it done on time, and you need to have done everything just right. When you hire somebody like SunRay to do it, they're going to do it right. You always want to have better leverage. Leverage is the way things get settled. Excuse me. If there is an attorney, a surety, even a debt collector calling you, and they do, use your construction attorney to get it resolved. And by the way, be real careful about using debt collectors yourself, because you sign up with them and they're not lawyers. I think I have a slide on this to come. They're not lawyers, and they will sound like they're lawyers. There's a company out of Texas that you really have to fish to figure out they're not lawyers. And they will call you and say, oh, I see you filed a lien on this project. We're just getting ready to do a class action on this, and you want to get in before you lose out. Well, there are no class actions in mechanics lien claims. So they're not doing a class action. They're just trying to put some urgency into you signing up with them. And when you sign up with them, even if you collect the money, they get paid. I just said this about not hiring cousin Vinny. And give your lawyer everything. Don't just give them the parts of your file that you think are important. And for heaven's sake, don't hold back things that you think are bad for your case or embarrassing or whatever. Your lawyer needs to know everything up front, because if they don't, it's going to drag things out. And I had the same thing just the other day. I'm working on a case, and all of a sudden I get this nasty letter back from the other attorney who says, well, I bet you didn't know this. Well, he didn't say it just like that, but he said, you're lying to me. I called my client and they said, oh yeah, we didn't tell you about that. We didn't think it was important. Holy cow. And I tell them to give me everything. So at least, you know, the worst place to find out about it is at trial. So yeah, it's really the terrible time, but you really, really, really want to give your lawyer everything up front. You've got to remember that it's not because you're right, it's because you can prove you're right without spending too much money. You may remember the Cattlemen's Association of Texas filed a lawsuit against Oprah, and Oprah was absolutely convinced she was going to win because she was right. And she was taking it that way. And you can read it in the book by, can't think of his name, her consultant, Dr. Phil. He had it in one of his books, a whole recitation of what went on and how he had to shake her almost to get her to understand that she was in serious trouble and she had to be able to prove she was right. She just didn't have to say, I did everything right, so go away. You have to prove it. Where are you going to go? Negotiation, mediation, arbitration, litigation. Read your contract. It'll tell you. And when you're signing that contract, be very careful about what these say. That's a whole different webinar, so I'm not going to take your time here. Your attorney is going to help you negotiate a good business judgment settlement. Are you getting paid 100 cents on the dollar? No? Okay. Well, how much is it going to cost you to try the case? Let's subtract part of that out before we say whether we should take a settlement. If you can't get a settlement, then you're just going to file suit. Using a service to collect, they're not your attorney. They can't make legal arguments. There's no attorney-client privilege. That's one of the big ones. Because you tell them something, they can be subpoenaed to come to court and testify. Your lawyer can't. You only get so far, and then they're going to hire their lawyer, and you're going to pay for it. And hiring your own attorney first just gets better results at lower costs. And like I said before, once you sign their contract, they're going to get paid no matter what. So how do you do this whole thing? Start with a good bid, negotiate favorable terms in your contract, serve that notice of furnishing. Be careful with your lien waivers. If you have enough time and it's not really volatile, serve your notice of intent to lien. File that lien when you're not paid. Maybe serve a bond claim that's available and hire your construction attorney to help you resolve the dispute and get paid. Are there any questions? Let's see. I don't see anything here in
So far,
share.
there are no questions.
Say that again, Ariella.
So far, there aren't any questions, but as you and I both know, sometimes a question can come afterwards. So I believe on your next slide, you might have our contact details.
I do.
Okay, wonderful.
I think I do. Let's go. There we go. There's my contact detail. Feel free to give me a call, and I don't charge you for it. Happy to tell you about anything that we talked about here today, and we can just work it out and get your questions answered.
Absolutely. Well, thank you so much, Russell, and to everyone on this webinar. Wish you a fabulous rest of your day. Thank you very much.